Welcome, everyone. You have joined Halt in the name of the law, choosing the right remedy for elder financial abuse. On behalf of the North Carolina Partnership to Address Adult Abuse, I am Ann Elmore. We, with the partnership, are pleased to have attorney Heather Whitaker Goldstein help all of us find the right remedy faster. Heather?
All right. Thank you, Anne. And I appreciate the opportunity to be involved, and I appreciate those of you who have come in to hear this session. I'm looking at the names, and I see some people that I know, some people who are doing work in this area similar to the work that I'm doing, and I also see some names that I don't know. And I'll tell you just kind of before I get started, I started working on this presentation about 2.5 years ago because in my practice, and I am an elder law attorney, and my practice is a combination of advising older adults on incapacity planning and litigating financial exploitation cases. And so many questions kept popping up for me about how to interface with the criminal justice system and how to interface with social services and other regulatory groups that I found that I needed to bring it all together, which was the beginning of this presentation. And once I brought it all together for myself, I found that the bringing of this combination of information together was very impactful with helping older adults come to terms with the fact that they are at risk just by virtue of being older for financial exploitation. And so since then, I've given this presentation about as many times as someone will let me come and talk. And I would encourage all of you as advocates in your own communities to do that, because at the end of the day, I think the right remedy for older adult financial abuse is educating the public and individual members of the public about steps they need to take to build their own protective strategies before they get to the point of being vulnerable. So with that as an introduction, and I'll say one more thing about that too. After I wrote this talk, the North Carolina School of Government came out with the most comprehensive and amazing resource that I'm sure that many of you may already be familiar with, but if you're not, I want to recommend to you the Legal Framework for North Carolina's Elder Protection System, which was written by Amy Wall and Meredith Smith at the School of Government. And there's a companion website that goes with it, protectadults.sog.unc.edu. I know that Meredith and Amy are presenting during this conference as well, and you may know them. I hope that you do. But if you've never looked at the website, I highly recommend going through those materials as a follow-up to understanding the right remedy. So let me share my screen. See, I haven't given you the benefit of looking at my squirrel through the whole introduction, but can you all see my squirrel now? All right, so this is Halt in the name of the law, choosing the right remedy for elder financial abuse. So the first, I want to spend a little bit of time kind of just defining the problem, and I realize that that is really preaching to the choir with this group, but for me, defining the problem is the threshold question I have to go through every time to decide what the right remedy is. So you all may be aware that there's actually no uniform definition of elder financial exploitation, older adult financial abuse, whatever we want to call it. There's not a single definition because it depends on if you're in the criminal justice system, or if you're in the social service system, or if you are litigating civil tort claims, or if you are before the clerk of court. But in general, I think we can all agree that in all of its forms, it involves the illegal, improper, or non-consensual use or taking of an older adult's funds, property, or assets. And I put non-consensual in yellow because in my practice, the issue of whether the activities were consented to by the older adult is the singular and most difficult issue in every case. Usually this illegal, improper, or non-consensual taking is happening in a relationship where there's an expectation of trust, and we call that a fiduciary relationship, or where an older person is targeted based specifically on their age or disability. And usually, often, there is an element of deception or intimidation. In the criminal justice system, that's a required element. And deception, I think it's helpful to think about. The deception does not necessarily mean lying to the older adult about the conduct that you are engaging in with respect to their finances. The deception could be a deception in pretending to care about the older adult or be their friend or companion as a means to being able to take advantage of them. Okay, no, really, what is it? Well, this is how the legalese is going to show up. And it's a very broad spectrum of conduct. It can look like withdrawing money from the older adult's bank account. Sometimes that is taking the adult to the bank and they're making the withdrawal. Sometimes it is by gaining access to their account and being able to make the withdrawal on their behalf, or having yourself added as a joint owner on the adult's bank account. It can look like having the older adult sign checks or having access to their checkbook and being able to forge their name, using credit cards without authorization, transferring property, so executing deeds in real estate. I see that a lot in my work. It can also be giving away of movable assets, automobile titles, changing the estate plan. I do believe that this is a form of older adult financial exploitation, although the fruits of it manifest after the adult is gone. But a lot of the litigation that I am involved in can happen when our older adult has passed away, and now we're looking at the impact of legal documents that were changed at the end of their life. Misusing a power of attorney is probably the most, I won't say the most common, but it is very prevalent right now, and it is one of the most difficult to unpack in terms of whether this is actually a situation of exploitation. Getting back to what I said before about the issue of consent, when you're talking about power of attorney abuse, you have a threshold question of whether the adult consented to the power of attorney, whether they knowingly executed the power of attorney, and then a secondary question of whether the activities that are being conducted under the power of attorney really were authorized and the adult understood they were consenting to those type of activities. Billing for unnecessary work. So you see this in contractor. It can be scams. People come to your home and recommend work that needs to be done that doesn't need to be done as a professional scam, but it also can be just a one-off of someone in a relationship with older adult who finds ways to charge them for work that they don't really need. Here's where insurance companies or financial institutions are at risk when there is selling inappropriate mortgage, investment, or insurance products to an older adult. And then, of course, there's coordinated frauds and scams, and these are the ones we're most likely to read about on television. Why the elderly? So this is, I'm going to go ahead and give you the whole slide here. This is not my professional field, and so make my excuses right away to any psychologists or neuroscientists we may have in the group. This is your field, and I have borrowed. But when I read about the different kinds of intelligence, fluid intelligence and crystallized intelligence, and when those peak and when they decline based on some of the psychological research, it helped me understand definitively why adults over the age of 70 are at risk, even without any diagnosed lack of no dementia, no formal diagnosis, just the normal aging process of the brain. So I encourage you to Google fluid intelligence and crystallized intelligence. You'll be able to read about this. But basically what they are is your fluid intelligence is problem-solving ability, and it is the area where most of your ability to protect yourself from scams and exploitation comes from. So I'll just read from an article that I pulled up this morning. Examples of the use of fluid intelligence involve solving puzzles, constructing strategies to deal with new problems, seeing patterns in statistical data, and engaging in speculative philosophical reasoning. So it's our inherent ability to take in information and make something of it. And that kind of depends what article you've read. I have read some that say this peaks at age 30. meaning after age 30, your fluid intelligence is declining. But I think some of the more recent studies in this area suggest that it may go until age 40 or potentially even 50 before it peaks. But regardless, 50 is about the farthest out you can get before your fluid intelligence is definitely declining, meaning you are not as able to solve problems or apply knowledge in the same way. So that makes so much sense if you just know the truth of you can't teach an old dog new tricks. And in my case, I am on the eve of my 50th birthday, and my 18 and 20-year-old sons are very frustrated at my inability to fluidly learn all of the new technologies that they use. And that I now understand is because my fluid intelligence has certainly peaked and may even be declining. But I'm not yet at risk for financial exploitation because of crystallized intelligence. And crystallized intelligence is another word for wisdom. It is being able to apply past experiences to future situations. And your crystallized intelligence continues to increase until you're about 70 years old. So between, say, 40 and 50 and 70, while that innate problem solving is going down, your wisdom is continuing to increase. And so you're not experiencing an overall decline in function. But around age 70 is when crystallized intelligence plateaus. So after age 70, you have plateaued wisdom and continued declining problem solving ability. And that is the area where diminished financial capacity rears its head and what I call the cognitive danger zone. And the most telling symptom of diminished financial capacity or being in the cognitive danger zone is the loss of healthy skepticism. Things that happen to you that when you were younger, you would have been able to spot as suspicious or be skeptical about, you are just not able to see that for what it is after a certain age. So this slide is where I spend a lot of time talking with my clients, trying to help them understand that they don't need a dementia diagnosis and accepting the inevitability that this diminished financial capacity is going to happen to them, which dictates a need to put a plan in place for when that inevitably happens. And why the elderly? Well, many of my clients come to me and they look like the woman in this cartoon who's doing all the work to care for an elderly relative. And she's asking herself, I have 3 siblings, where are they? And a lot of perpetrators wind up being the woman in this cartoon. And one of the things to understand about that is that there's not even an awareness on the part of the perpetrator in these situations that this is exploitation. Because if you are in there daily living, caring for a parent, and your siblings are nowhere to be found, then one of the very common things that happens is just a feeling of entitlement, or that mother would have wanted me to have all of this because I have given all of that to her. And that might be true, or it may not be true. And it's difficult to tell if mom is in diminished financial capacity. So the wealth concentration in the United States is one driver of this epidemic of financial exploitation. And that is because until about the 70s or even 80s, most people retired on a pension. So they didn't save up a huge nest egg of assets to live off of as an older adult. They were reliant on an income stream from an employer that they probably worked for 50 years. Now, pensions are much less common for most people. Most people have a nest egg that is their support in their later years, and it's that nest egg that makes them really vulnerable to exploitation, because there is a lot of wealth concentrated in individuals over the age of 70 in this country. Also, the 85 plus segment of adults is the fastest growing segment in our population. So you compound the number of adults who are in this age group and the wealth that they have, there's a lot of money out there for the taking. They are most often lonely, and many of them lack self-sufficiency, and that makes them vulnerable to whoever comes into their life offering caretaking or companionship. And so here's another cartoon of another family that is frequently in my office. We need a plan for mom's care. One does all the work, one goes AWOL, one undercuts our decisions, and one steals her stuff. So family members and fiduciaries, well, family members are one of the most common perpetrators of the exploitation of older adults financially. And as I said before, most often they don't feel that that they're doing anything wrong. They feel very entitled. Fiduciaries, that's the legal word for someone who is formally in a position of trust or responsibility with an older adult. That could be agent under power of attorney. It could also be trustee of a trust. Caregivers, friends, contractors, and scammers. These are all people who are going to be in a position to gain the trust of older adults. And the complicating factors, and I feel like this slide is a setup to the ending keynote that we have tomorrow. Paula and Abby are giving us, I think it's called Let Me Drink and Gamble in Peace. The teasing out of the older person's right to make bad decisions or decisions that others might not agree with, their right to use their money responsibly, from a situation where advantage is being taken is extraordinarily difficult and ultimately the single issue in cases that wind up in serious litigation after the fact. The question of consent is proffered as a defense to the perpetrator in almost every case, and they will say, grandma knew that I was doing it and wanted me to. Other complicating factors, and those of you who work for social services probably see this every day, is that the older adult may just be confused because of diminished financial capacity or other cognitive impairment. They're not sure what they've done. They're not sure whether they gave consent. They think maybe they did give consent. They're not sure if they wanted to, and they're embarrassed by the confusion. And so that dynamic can make it difficult to get in and offer protection. And then there's the very real fact that they may just want to protect the perpetrator. If it's a granddaughter, if it's a child, even if it's a trusted caregiver, the older adult may not want to do anything that will get that person in trouble. And so when we look at remedies in those kinds of cases, when the older adult is still a part of the protective action, coming up with a solution that doesn't send the perpetrator to jail or has the least consequence for the perpetrator possible may be the best solution in situations like that. So at the end of the day, it takes a village to stop elder financial abuse. And that village is actually us. I don't know how many of us actually look like one of these guys. I don't. But we all have to come together, and the North Carolina Partnership is a very important way, and this conference for us to be able to do that. Here's the village that I see every day in my work, and I hope that it's represented here today and tomorrow for this conference. And I'll offer the top 4 as the ones that I most frequently interface with and where I'm going to spend most of my time in the presentation. There's the law enforcement angle, the criminal justice system, criminally prosecuting perpetrators of financial abuse. There's the Department of Social Services, and its focus is protection of older disabled adults and being able to investigate and take protective action to stop financial exploitation when it's happening. There are attorneys, and this is where I work, private and nonprofit. And I think it's important that everyone know, if you don't, that North Carolina Legal Aid has an elder law project and is able to do most of the type of work that I would do for paying clients, for clients that can't afford a private attorney. And it's an important, having legal aid consider and screen a case can be really important if you have a situation where there really may be financial exploitation, but the assets are not, and at the end of the day, in order to justify bringing on a private attorney to walk through some of the options that I'm going to go through in this proceeding, there needs to be, it's a cost benefit of how much really has potentially been lost, how much is at stake. So private and nonprofit attorneys. And then financial institutions are a growing partner in this area. They're really at the forefront of the financial exploitation epidemic, and they know it. And I saw that Peter Gwaltney is presenting in this conference, and I got to hear him speak a couple years ago about the work that's being done in financial institutions. And I appreciated hearing just how seriously they take their responsibility in this regard.
Heather, just to give a shout out, Krista Kretschmar, I believe she's with the State Employees Credit Union, is on this webinar, and Melanie Earnhardt with Legal Aid of North Carolina also are attending.
Good, I love it. See, we have our village here listening. So hopefully this isn't too much preaching for the choir, but you know, even if everyone who's listening to this occupies one of these boxes on this screen, it's so important that we know who's sitting in all the other boxes and that we know when to call them. And that's really kind of what this is about for me. And getting back to plugging Meredith and Amy's resource, that's what the School of Government has given us as well. And Anne, who is our moderator today, is with the North Carolina Secretary of State, and they hold space in the regulating of financial institutions so that when fraud is being perpetrated by an employee of an institution, they have some oversight and some ability to be involved. Of course, we all have probably heard representatives from the Attorney General's office talk about their work in the fraud and scam area and the great job they're doing with public awareness in that area. The long-term care ombudsman, advocating for older adults who are in nursing facilities. And if the exploitation is happening at the hand of a facility, then you definitely want to involve the ombudsman. The Social Security office, they have, I'm sure you're all aware, a procedure for getting a representative payee appointed when it's the Social Security that is being misappropriated. And for some adults, if the only asset that they have is Social Security income, then the most direct pathway to resolution might be going straight to the Social Security office and working through their representative payee procedure. And of course, if it's the representative payee who is doing the exploitation, they can swap that person out, and they can also they also have a remediation procedure. It's deep in the regs, but they can attach future Social Security income from a perpetrator to repay to the older adult. And I've never had to do that, but I was very interested to learn that. And then of course, there's elder justice teams and MDTs. That is the emerging area in the state. We have one in Buncombe County that's been putting itself together over the last 2 to 3 years and is really focusing its efforts right now on educating our team locally here doing this kind of work with each other to be sure we know when to call each other. And then the last 3, this is also very much my area, and I know that it may be many of your area, is that you have those older adults in front of you. They may be your clients, they may be your partners, or the family members of older adults, or just concerned citizens. And I think in these last 3 boxes is about all of our collective commitment to public education and making sure that people understand the epidemic, the nature of it, and how to protect their family members.
Heather, Lisa McDowell points out the role medical providers can play by seeing the decline in exploitation.
You know what? Thank you. I'm writing that down, and I'm going to add that every time I give that slide, someone tells me about a new box to add. But that's it's a great point, and medical providers are usually really seeing this from a very different angle, and we want to include them in our village. And anybody else who thinks I've left out a box, feel free to tell Anne so she can yell it at me. So that gets to how to choose. Among all of the people in the box, where are we going to go when someone presents to us with a fact situation that sounds like an older adult may be financially vulnerable or being taken advantage of? To me, the questions that drive which direction we're going to go in have to do with these factors that I put on the left side of the screen. One is urgency. Is this something that happened in the past but is no longer ongoing? Because if that's the case, we know we don't need DSS probably. We would be looking more for a conversation about whether we need to find a repayment. And that's one set of strategies. but the status quo is stable. And I think that's what you always have to, it's what I always ask myself is the status quo stable? Because if it isn't, then you probably have an urgent situation and you need to take a pathway that will be faster. Financial resources, how much is really at stake? If the exploitation is ongoing, is there a lot of money that may be taken? Is it a small amount of money? And what are the financial resources of the person who is presented in front of you? And this is very relevant to me because I'm in private practice. And so, except for the pro bono work that I'm able to do, I have to make a living and I have to be paid. So that drives a certain set of questions about whether this client would be better served with private litigation or helping them get to a pathway, whether it's legal aid or social services or the criminal justice system, that doesn't cost money for people to access. Also, if it's a repeat perpetrator, I think is relevant. I think for repeat perpetrators, then the criminal justice system has some real teeth because you want to get that person off the street, so to speak. And you have to think strongly about that avenue from a kind of public protection point of view. But if it's not a repeat perpetrator, when you're talking about someone's granddaughter who's taking advantage of grandma, there's pretty little risk that she's going to do this over and over and over again. And so I think then you want to be looking for pathways, like I said before, that will minimize the negative outcomes for granddaughter while stopping the exploitation. Control, for me, this is the conversation of who has come to me with the concern. It's rarely the older adult. It's usually family members or a neighbor or someone in the community who is concerned. And so one of the questions that we have to ask is, how much does this concerned person want or need to control the proceedings? And I find that if it's children or close family members, they have a high need for information and involvement and control. If it's just a concerned next door neighbor, they may be more likely to say, I just want someone to know about this and look into it, but I don't need to continue to be involved. And so that control, if there's a high need for control, I think that pushes you more towards some of the private remedies that I can offer because I am taking instructions from the client who hires me and giving them all of the information that I find out, versus if you go adult protective services, law enforcement, you're not really in control of those proceedings once you get them started. And then resistance is the older adults that we are concerned about likely to push back on efforts to help them. If they are, then Department of Social Services might have some problems being able to intervene. And that might be a situation where we need to consider judicial remedies in order to take away the older adult's power to resist, i.e. guardianship in appropriate cases.
Heather,
So,
what role can church and community play in all of this?
Yeah,
Karen Jean McElveen suggests that.
Well, of course, we all know that everyone is a mandatory reporter to Adult Protective Services. And so I think church and community has a role to play. If you see something concerning, it should absolutely be reported to DSS. DSS can take it from, and you don't even have to make the decision, is this appropriate for the criminal justice system? Because DSS can make that determination for you. And then I think that the other really significant role that church and community can play is in the education of congregation and building trusted networks in congregation. And I will circle back to this at the end, but I think having more people in a person's life rather than fewer is protective for them. And having a network of people who are regularly in a person's home that are all trusted by that person is protective for them. And so I think that the best place where I see churches is being able to build the older adult care networks where the community really is participating in providing companionship and trusted caregiving, even in a way that allows for transparency into the older adult's life. Okay. So law enforcement, here are kind of the pros and cons, and this isn't where I work, but I work with them. So you probably are aware that the financial exploitation of older adults is a crime in North Carolina, and there's a very specific legal definition for that crime that law enforcement and district attorneys have to work inside of in order to determine whether any particular case is one that they can prosecute. But they do have the power to, they have investigative power, so they're able to get a lot of information, search warrants when there's probable cause. They have the ability to subpoena financial records. So if the evidence of wrongdoing is going to be embedded in bank statements that the church family isn't going to be able to get, then the ability to subpoena those records can come with a report to law enforcement. And the criminal financial exploitation statute allows for the freezing of the assets of the perpetrator when there's clear and convincing, if you're pretty far along and you're pretty sure that exploitation has occurred, but prior to the criminal proceeding, those assets could be frozen, which could be an important tool when there's a lot of money at stake. There also can just be a deterring effect of the investigation. Two big advantages of this pathway is that there's no cost to the victim or the advocate. So that's, the victim doesn't have to have any money to pay a lawyer, and the advocate, if it is a neighbor or a caring church member, doesn't have to have money to hire a lawyer either. But you lose that control. And so that's what I was saying before. When you think about how much control does the advocate want to have, you won't have a lot of control with law enforcement. At the end of the day, the teeth that law enforcement have is punishment. And so for a repeat offender, you're going to most likely get that person off the street, so to speak, either by putting them under parole or even sending them to jail. And then, of course, restitution is available to pay back the victim if the offender still has any of the assets. Authority and influence are problematic. What I mean by that is really the power of attorney abuse cases or trustee abuse cases, fiduciary abuse cases are harder. And I'm not saying that law enforcement can't successfully prosecute those, because they do, but those become less clear-cut than, say, the lawn mowing guy who's fleecing older adults by charging too much or mowing too frequently or whatever. Because when you have the trust document or the power of attorney document in place, there is this initial threshold question of whether everything that person has done was consented to by the older adult. And the embedded questions of capacity and influence are harder to tease out in the criminal context, I think.
Heather, in this, when you're talking about guardianships and also persons operating under the authority of a power of attorney, aren't their behaviors limited by their fiduciary responsibility to act on behalf of the individual who is in their care? And aren't their expenditures scrutinized more closely than otherwise they might be? And aren't they limited by the scope of their authority?
Yes. Yes to all of that, except whether their expenditures are scrutinized. And they're not being scrutinized in every case, although you can build that in. But I think that so yes, they have duties, and yes, if they violate those duties, there's a remediation, and that's a civil legal pathway. Not so much a crime, because in the criminal justice system, you're dealing with the actual crime. And in some ways, the civil remedies of filing a lawsuit for breach of fiduciary duty, which is what that looks like, or breach of trust, if it's a trustee, is you have a lower, any of you are old enough to remember the OJ thing. Remember, there was a criminal prosecution that was not successful because we didn't have the beyond the reasonable doubt standard of evidence. But over on the civil side, in the OJ case, you're just going for a personal injury. It's a preponderance of the evidence, which is a lower evidentiary threshold. So that is, I think, easier sometimes in the power of attorney abuse cases to get the civil remedy than the criminal remedy. So let me kind of get there. It's a good question, but it's a hard one to answer quickly. So here's DSS. The downside to DSS is that it just has jurisdictional limitations. You've got to qualify as disabled under the relevant statutory definition, which means not everyone over the age of 65 is going to be eligible. And getting back to my initial sort of laying the foundation of diminished financial capacity, in my experience, there are lots of adults who have diminished financial capacity who are not disabled and would be screened out by DSS. But that's not to say that you shouldn't report these cases to DSS, because I think that you should. They also have to be unable to access protective services on their own or with assistance, and they have to consent. So if DSS goes in there and talks to the older adult and makes the determination that the older adult has capacity, and the adult says, I don't want you to intervene, then that's the end of it. And there are cases of lack of capacity where an adult is being taken advantage of because they simply lack the mental capacity to protect themselves. But there are also cases of undue influence where the adult may have capacity, but they are in such a vulnerable state that they are being influenced, and their decisions, the decisions that they are making for themselves, are really the product of someone else's influence. Those are the more difficult cases, I think, for DSS to find. So DSS may be more effective when the lack of capacity on the part of the older adult is more apparent. The upside to DSS is that it's easy for any of us to access. We only have to call and make a report. They also have easy access to medical records, care provider records. They can get financial records. There may also be a deterring effect of a DSS investigation. So sometimes if you're not sure if exploitation is going on, or maybe you have a perpetrator who is just in the beginning stages, an early DSS investigation could potentially nip that in the bud in some cases. And the no cost is a major advantage of having our social service protected. It's also confidential. Yes.
I'm so sorry, Laurie.
No, I'm glad.
Heather, Laurie has a question, and it harkens back to law enforcement. What level of evidence is needed for law enforcement to request bank records of a purported exploiter during an investigation? And Laurie notes that there is just a small window to freeze those assets before they are gone. And often law enforcement says, well, we need more proof, which obviously will be provided in the bank records the social services worker expects. So,
yeah, so it's probable cause on a warrant. Now, there's a new statute that allows DSS or law enforcement to go to district court and get financial records without giving notice to the perpetrator or the victim. And I've not had occasion to be involved with someone invoking that statute, but it is an attempt to address that problem. And yes, it's a narrow window, but the opportunity to be able to get records without giving notice is the way that you would potentially do that. But yes, that's one of the challenges of law enforcement route is, again, getting back to control, is that you don't necessarily know if the investigator in your case or the DA will be persuaded or feel that they have enough cause to be able to bring this, or that a court would allow it.
Heather, even assuming that you do get your DA and law enforcement to go along with, Debbie Lee points out, with COVID shutting down courtrooms for over a year, many resources for prosecution have been shifted to major crimes and away from what is perceived as lesser crimes such as exploitation. So she asks, what remedies and suggestions can you give when you've got perpetrators you're concerned about?
So I think then if your criminal justice system is not able to take this on, then you have to look at private remedies. So let me kind of move to that. I'll just give you a quick on financial institutions before I get into more private remedy side of things. Know that banks, of course, their hands are tied if their adult account holder is in front of them asking, in the situation of going to your bank and saying, I want to wire $10,000 to my grandson who's in jail in Oklahoma. The bank can't really say no to that, but they can report it to DSS. But hopefully you all know about the list of trusted persons which banks can offer to their clients. And I tell all of my clients to go to their bank and ask to put trusted persons on file, because if the trusted persons list has been put on file and something suspicious is, and the older adult is, I say the customer is suspicious, but I really mean the person is sort of self-exploiting, doing allowing them to be taken advantage of through their own actions. The trusted persons can be called. Bank's still going to have to go along with customer instructions, but you can get that third person in there. Of course, when it's the fiduciary who is suspicious, the Uniform Power of Attorney Act has a whole protocol for protections, and the bank can refuse to honor a power of attorney, can request a legal opinion on the validity of the power of attorney, and has some other tools. So what I would say to community members who are concerned is, if you're suspicious, you may want to call the financial institution where you know this older adult banks and put them on notice, and they may have other tools in their toolbox that they can implement. So private remedies, I always say keep calm and call an elder law attorney. And our work is education and prevention, kind of first and foremost, but then also intervention and compensation. So let's get straight to that intervention question that you're all asking about. When it just doesn't feel like we're going to get where we want to go with DSS or with law enforcement for whatever reason, this is what I call the bird in the hand, something that you can do relatively quickly when exploitation is happening now. That would be certain remedies available before the clerk of superior court. So you do have to file a legal proceeding, but when you were litigating in front of the clerk of court, it is faster and it is less expensive and it is less formal versus filing a lawsuit in superior court, which is slower and more expensive and more formal. But usually before the clerk of court, you can file something and you can get a hearing sometimes within 30 to 60 days. And the most common proceedings that you would want to know about and consider filing would be in the case of power of attorney abuse, you can file a request for an accounting and go in and have a hearing and put on the evidence that you have that you are suspicious, and the clerk will order the fiduciary to account for their activities as POA and provide the backup. And that's a new tool that we're seeing a lot of those being filed. It's we haven't had the opportunity for many of these cases to go up to the Court of Appeals to see what the challenges are going to be with them, but it's kind of a quick way to get a peek inside the fiduciary. Of course, if there really is funny business going on, then you're probably going to get some significant pushback from the fiduciary in this proceeding. And I think that when the presence of that pushback in and of itself is informative for whether or not you might need to take more aggressive action. And I always say, for private attorneys, when you're representing the fiduciary, transparency is a virtue as much as you can be transparent. Although again, there are times when someone is not being transparent, and that doesn't necessarily mean they're taking advantage, but it may be that the older adult, when they set up their plan, wanted privacy. And so that's one of the complicating factors we have to work around. You can also remove the fiduciary, and by that I mean remove a trustee and replace it with a neutral trustee, or remove the power of attorney. That's also proceeding in front of the clerk of court that can happen relatively quickly. And the first two would allow you potentially to avoid having to go for guardianship over the older adult, which is, I always say, the nuclear option in my practice, because we don't want to be in the regular practice of taking away people's rights to self-determination, which is ultimately what guardianship is about. But sometimes when you have the resistant or non-compliant older adult, and you believe that they are resistant or non-compliant, not of their own free will, but either because of mental infirmity or influence of another person, then you've got to look at guardianship. And interim guardianship, you have to be able to show that there is a reasonable cause to believe that the adult is in imminent financial danger. But if you can make, and that they are likely to be found to be incompetent, meaning they can't make or communicate decisions or manage their own affairs. But if you can show reasonable cause for imminent harm, you can get an interim guardian appointed, and that can happen in as short as 5 to 7 days sometimes. So it's a good tool. Get that interim guardian in there who then immediately has access to all of the information. And along with the interim guardianship comes a taking away of, if it's a power of attorney where the abuse is happening, you can revoke the power of attorney.
Heather, what suggestion would you give Debbie Lee and the others who may come across victims with limited funds, but need an attorney to do just what you have outlined?
Yeah, so that's where I love legal aid. And if they can be screened in, because at least in my community, we have the legal aid attorney that is here is doing all of the same kinds of proceedings that I'm doing for paying clients, but she's doing it for clients that meet their income threshold. So I call her regularly when I have one of those, and they can screen them in and see if they meet their criteria and do it. But that's a first call. If legal aid can't screen them for whatever reason, then sometimes you can find a pro bono attorney, or then again, you got to fall back on DSS, because DSS can also go in with its attorneys and get interim guardianship and permanent guardianship, and they will do so when there isn't anyone else in the adult's life who can take protective action for them. So those are your clerk of court proceedings that are relatively quick. The other thing I like about all of these is that the clerk can order mediation. And there are some cases that are really family disputes, and getting the family into mediation can actually be a great way to persuade everyone involved to get a neutral third-party fiduciary in place for this older adult and get some good, transparent accounting so that everyone's suspicions are calmed. And we have lots of good outcomes when we're able to get families to mediation in situations like this. All right, here is non-judicial remedies, but I think things that are quick that authorized individuals can do. And this would be an agent under a power of attorney, or a joint asset owner, or even in some cases, the children, the neighbors, maybe the church friends. So if you're authorized, or if you have a relationship with the older adult and could encourage them to close a bank account or move their money somewhere else, that may be a strategy in certain fact situations where someone has gotten unauthorized access and is taking money out of a particular account. For scammers, getting a new phone or computer. Everyone should have their credit frozen, and if you have POA for someone else, you can do it for them. And so you want to be sure that the credit is frozen so that no one can take out credit cards or incur debt in the older adult's name. Requesting bank records, again, if you're authorized to do it, do it. And one of the things that I tell my clients as a proactive strategy is pretty much once you're over the age of 70, I'm having a conversation with you about whether you want to just have a trusted person who gets duplicate copies of your bank statements. And that would ideally be not the person who is named as your agent under power of attorney, or who is your go-to financial agent when you need it. It's some other person who's never going to be in a position to access or manage your money, but who you trust enough just to watch. Changing or adding caregivers. If we're worried about undue influence of a particular caregiver, sometimes we just need more people going in there, or getting a person who is developing a relationship from which they could take advantage, getting them out of the way if you can. And then being noisy and avoiding isolation. That gets back to my answer to the what can the church do question, is it's the isolation of an older adult, and when there becomes just one person who is their lifeline for everything, where they're really vulnerable. And so the more that communities can be noisy, be in visiting, be around, give them more than one trusted person to share something with, that can be preventive. Sorry. And execute new documents. I'm actually working on one of these this week. Usually I say you got to be, and by that I mean revoke the existing power of attorney and execute a new power of attorney, or execute a document removing your current trustee and putting a new trustee in place, or amend your trust to add a co-trustee. Well, that's a very effective way of stopping that kind of exploitation, but you really have to proceed with caution, because if the older adult lacks the mental capacity to execute legal documents, then the new document that you've had them execute could potentially be invalidated. And so you have to kind of weigh what is the likelihood of a challenge. The case I'm working on this week is a longtime client of my firm, with a client who had a very good plan in place with lots of third-party advisors, not her family members, that were going to take over for her. And we learned this week that she has abruptly gone to a different law firm and executed a new power of attorney, naming one of the people that we know was not part of her plan as her agent. And so for us, getting a meeting with her and being able to assess whether we think she still has capacity, and trying to better understand why she's done that, making sure that she remembers what her plan was, we might have a window in there to talk to her about revoking that power of attorney and reinstating her former plan. We won't know until we see her, but if that is a viable option, it's certainly preferable than talking about whether or not she needs a guardian or some more aggressive intervention. But that needs to be done thoughtfully and certainly with the advice of legal counsel. Okay, this, I won't spend as much time here, but ultimately a remedy is going the distance, recovering assets. You're in this bucket when the ongoing exploitation is over. That could be because you've already done one of the shorter term remedies that we just talked about. Maybe you have a guardian, maybe you've changed the fiduciary, maybe you've had success in the criminal justice system, or DSS has successfully taken protective assets. You've stopped the bleeding, and now you have a new person who has gotten in there and been able to assess how much was taken. Or we're in this phase because the older adult who was being exploited has died, and now you have the family members just beginning to discover what happened when no one knew that it was going on before. And so the process of going to court to get back assets that were taken is long. It's typical time to jury trial in a superior court proceeding would be 1 to 2 years. It's expensive. Going to jury trial could be $50,000 to $100,000 to $150,000 or more, depending on the case. And it can be very emotionally draining on those involved, who will likely have to be deposed and spend time answering questions and relive this unpleasantness over and over and over again. So there's a cost-benefit analysis that has to happen to decide whether or not the potential victim wants to do that. But if they want to, you have to ask yourself, is there someone who could file it? And if the older adult is still living, then the ability to bring a civil claim on their behalf rests only with them. And I've got my third bullet point here. I always say beware of highly motivated children. I always have the highly motivated children who want to sue for a significant sum of money that was taken from the older adult, but they don't get to bring that lawsuit while the adult is living. So either the older adult has to be willing to do it themselves, or there has to be a guardian to do it, or in some cases, the agent under a power of attorney can do it. And so you really have to make a determination about whether that makes sense. And now after the older adult has passed, then whoever are their heirs or the executor of their estate, depending on the type of assets that were taken, they then have standing to bring the claim. And I think one of the things you have to think about in terms of timing is understanding that if you start a proceeding while your older adult is living, so let's say their guardian brings the proceeding against the perpetrator to get assets back, and if the older adult dies, the guardian's authority to continue with that lawsuit immediately ends upon the death of the older adult, and you have to substitute in the executor of the estate. And often in these cases, the executor is not the same person. So that can be a complexity that may warrant waiting until after the older adult passes, but it really depends on really how healthy they are and how much longer we think they'll be there, because we also have statute of limitations concerns. So there's a big question to have at the beginning about who can sue and when is the right time to sue. Also, in these cases, you need to be familiar with pre-judgment remedies, and we're now talking civil. So this is not on the criminal side where the DA in some cases can get an order to freeze assets. This would be on the civil side. There are a variety of options. Claim and delivery would be when the older adult or their fiduciary says the perpetrator has taken their physical items. And I actually had one of these where there was a very valuable jewelry and art collection that had been taken. And so we did claim and delivery, where you go to court and you know you're going to have to litigate who really owns these things, because in my art and jewelry case, the person who took it said that it was a gift from the older adult, and so they belonged to him. And we were saying, no, she didn't have the capacity to give you that gift. Claim and delivery allowed us to get all the stuff, put it in storage. The only downside to that remedy is that you have to post a bond. And so you may not be able to do that depending on, it depends on the circumstances. Attachment is attaching the assets of the perpetrator before you get a judgment against them, because you have some reason to believe that they're going to dissipate those assets. TRO is a restraining order or an injunction. Those are useful when the assets are in the hands of a third party. So there may be a bank account that is in the custody of the bank, but let's say the perpetrator is a joint owner and could theoretically withdraw those funds. That would be a good time to get a restraining order or an injunction so that the bank doesn't pay out those assets to the perpetrator who's a joint owner while you argue about whether they're legitimately a joint owner. And lis pendens is for real estate. Really, the name of the game in these cases is money damages, and you can get compensatory damages, but where the conduct was willful and wanton, in other words, grossly intentional, you might be able to get punitive damages in some cases. And then in other cases, particularly against contractors, you may be able to get treble damages, which means the actual compensatory damages times 3. There is also a remedy, 5 minutes left, I'm gonna wrap up. There's a remedy to invalidate any legal documents, particularly deeds and wills, and we do those kind of cases all the time. That's called rescission. Or sometimes the exploitation was changing the beneficiary designations on someone's IRA, retirement type of accounts, and we may need to go to court to reinstate the true beneficiaries.
Heather, speaking of that last slide, if you would, invalidating documents, we do have a question from Lori Gallagher, and she asks, have you ever had the situation where an individual was maybe, you had cause to believe an individual was using an old POA to exploit the elderly individual? You believe there's a new POA, and there is an attorney in whose custody that new POA is reposed, and that attorney is saying, no, that's attorney-client privilege, and they won't release the POA. So you can't compare it.
I think that, gosh, that's an interesting question. I don't know if that I can invent the procedure off the top of my head. It seems like the attorney ought to have named individuals that he can release the information to. And sometimes I would ask, what do you need to see? Sometimes if you give the attorney a letter showing that the person is incapacitated, then they will. But I think the other thing is, it's hard for me to understand if someone is actively exploiting under an old POA and an attorney knows that that old POA isn't valid, why they would not partner with you. So that is kind of a perplexing one, but I'm sure there's a remedy. I just can't think of it with the clock running on me at 3 minutes left. I just think you need to get on the phone with that attorney, and because it's attorney-client privilege, but it's also, there's an ethical obligation to take protective action if your client is being exploited. And I think the attorney's in a complex ethical situation if he's standing in the way of that. Which gets to legal malpractice as another subset of this, but I don't have a slide on that, so we could do that another day. This one, just to say, what do you have to prove in these big cases where you're clawing back assets? Usually the grounds to set aside all of these transactions is about overcoming the defense of consent, and that's capacity and influence. And you usually have to develop medical evidence, observational layperson evidence about the person's abilities and functional, like what could they do? What types of things did they do for themselves? And it's not a cut and dried, capacity is a legal determination, not medical. We're wrapping down, so I guess that's it. Gosh, I didn't get through as much as I thought, but thank you for coming to the session. It's been great to participate with all of you. And here's my final list of 10 proactive steps, although it's not 10, but file your list of trusted persons, freeze credit, give someone duplicate copies of financial statements, think twice about joint ownership, transparency is a virtue, and convene family or team meetings. This is a speech that I give my clients every day, and I hope that you will as well. Thank you. Are we good? I appreciate all of you. Yeah, I see you, Lori. Code of ethics wasn't much help, unfortunately. I'm going to be waking up in the middle of the night thinking about that one.
Thank you so much, Heather. This has been fabulous. I don't know if you're seeing the chat, but you've had some wonderful, wonderful kudos from the attendees of this session.
Good. Well, I'm looking forward to the next session.
All right, y'all, we will be shifted over in just one moment. The transition is in progress. Just bear with. Remember, don't leave the conference. You'll be moved automatically. Thank you, Heather.
Thanks.
Thank you. Welcome back from the break. At this time, I'm going to ask Tadra Martin to turn on her camera and her mic so that she can introduce our afternoon keynote speaker. Tadra, I think you may be muted still, so. Tadra apparently is not having any audio, so I am actually going to grab the little flyer here and let me introduce Michelle for you this afternoon. Michelle Guarino, this presentation will provide training on how individuals can employ trauma-informed care when interviewing individuals who have been abused or have trauma. She will explain trauma-informed is how and is and how to infuse it in their work. Also, she will discuss things to look for to determine an individual's decisional ability awareness. A senior lecturer for the North Carolina State University School of Social Work, Michelle Guarino earned a Bachelor of Social Work from the University of North Carolina at Wilmington and a Master of Social Work from NYU, New York University. Michelle is a licensed clinical social worker and has worked with gang-affiliated high-risk youth and families since 1996. Michelle began her career as a youth intervention counselor for the New Hanover County Sheriff/Wilmington City Police Gang Task Force, a first of its kind position employing a civilian within law enforcement entity to intervene with gangs and gang members and families. Michelle has developed numerous successful prevention, intervention, diversion, and reentry programs that subsequently were recognized with multiple awards and accolades. Michelle's 23-year work history has focused on working with law enforcement settings and has held titles such as Division Commander, Program Director, Gang Counselor, Crisis Unit Supervisor, and Crisis Negotiation Team. So Michelle, at this moment, I'm going to turn it over to you.
Fantastic. Thank you, Kevin. I am going to share my screen with you guys, and hopefully we can get started. If you cannot see that, just let me know. Awesome. Awesome. You know, when Kevin was reading that, anytime that I know lots of us speak at conferences and things, you hear this laundry list of accomplishments and things you've done. And sometimes it just speaks to me that, wow, I am getting old. So thank you, Kevin. I appreciate that validation of my age. So we're going to talk a little bit about creating a trauma-informed care environment. And for some of you, this may be new information, and for others, this may be a duplication of something you've heard. It also may sound incredibly simple. And what I've found working with trauma is there is not this standardized training that many agencies are offering their employees. There's not this trauma-informed approach that many universities are taking as we're training counselors and psychologists and social workers. So I think one of the best things to do is to start very simple and go through information at a very slow and standard rate, if you will. So trauma-informed care, what it is, and what you'll find is there's a lot of words and a lot of writing here for those of you who like to take notes, and for also those of you who want this presentation. It's a good piece of material to refer back to. But really, trauma-informed care is talking about the agency, the program, the organization, how we advocate, how we lobby, what the community thinks, the stereotypes that are around someone who is a survivor, and how we respond. How do we take the individual's needs and their personal experiences into how we're working with them, from the front desk staff of an agency to those clinicians working directly with them. One thing that is the most important is that there has to be a realization that the trauma is widespread, that it impacts so many facets of a person's life. We have to recognize the signs, the symptoms in trauma, and how that affects secondary and tertiary parts of that particular person's life. We have to know how to respond. We have to have the patience. We have to be able to walk alongside. We have to be able to ask the question, what have you been through? We have to incorporate trauma into our policies, our protocols, our procedures, how it is that we respond, how it is that we start to work with the individual with a trauma-informed lens. And we are always seeking to actively resist re-traumatization. And we want to create an environment where re-traumatization is less likely to occur. So if you know a little bit about trauma-informed care, you will know that there are tons of different concepts around what it is and how to deliver it. This is one of my favorite ways to look at trauma-informed care, and it breaks it down into 6 kind of silos where we can start to look at if we are doing this and in what way, and if not, where's the challenges and how we're meeting these people where they are. The first is safety. Throughout the whole organization, staff and the people and clients that we serve, we have to make sure that we are meeting them in an environment that is physically safe, psychologically safe, and that they feel that this is a space where they can be comforted and start to disclose things when they're ready. We have to create a space full of transparency and trustworthiness. We want to work these into our daily operations, how we communicate with everyone that works in the organization, as well as the clients and their families. We want to build the goal of trust. We want to maintain trust, not only with those that we are serving, but those that they are describing as a support system. Peer support and mutual self-help. These are integral to the organization and service delivery approach. We have to make sure that we have these components so that they feel empowered, they feel advocated for, and that there's the ability for them to reach out to build their coping skills to be able to self-help. Collaboration and mutuality. There is a recognition that healing happens in relationships that are meaningful, sharing of power and decision-making. We all know as clinicians that this is one of our ethical values. We have a client right of self-determination. We mutually meet clients where they are. Goals and objectives, treatment planning is all mutual relationship. So this should not come to any surprise, but this is absolutely a must when we're treating someone from a trauma-informed perspective. Empowerment, voice, and choice. This is when our organization aims to strengthen the staff through training, the client and family members through psychoeducation, and realizes although someone may have been through a particular or specific kind of trauma, that the experience and the response is individual to each particular client and their family members or support system. We have to build upon that. We have to meet them where they are and be able to offer choice in treatment, choice in disclosure, and a voice in advocacy in how it is that they would like to meet this trauma where it is. We also have to consider cultural, historical, and gender issues. We have to move past those stereotypic biases and culturally responsive services, language, leverages. We have to move toward a healing value of traditional cultures, connections, traditions, and recognize that historical trauma is a facet of trauma, and we must address that. Trauma-informed approach is designed, number one, to avoid, re-traumatization. That is number one when we're working with someone who's experienced trauma. We focus on safety first, environmentally, psychologically, whatever that may mean as described by your client to feel safe. And we have to be committed to doing no harm. No harm in that space, no triggering, and no re-traumatization. We have to facilitate participation and meaning involvement of our clients, our families, our trauma survivors. They have to be a part of planning services, programs, treatment, etc. And those components all come together to build this great, beautiful thing of trauma-informed care. So how do we avoid re-traumatization? We hear this quite a bit, that when someone's experienced trauma, we tread very lightly. We know re-traumatization means that we are going to trigger or that we might take them back to that situation or incident. But how do we avoid that? Well, number one, we use psychoeducation. Tell them that you want to know about these hugely important events, but we don't want to take that experience and make them worse. We want to talk about how trauma affects them, affects their nervous system, how we respond, how when we hear, smell, or taste something, it might take us back to that particular situation. Psychoeducation has to be first and foremost. We don't want to dive into a situation and ask them to tell us about that experience. We want to tell them that there is validation, and we want to normalize responses to trauma. This is quite a big chunk of time that we'll be spending with clients, is psychoeducation. And if they have family members or a support system that are participating in a therapeutic program with them, offer that same psychoeducation to them. Using containment. This is something that I use quite a bit when someone comes in and they have a lot of trauma, complex trauma, or perhaps are struggling a bit, to talk about daily activities because that trauma is just kind of hanging out and they don't know what to do with it. So we identify a receptacle. It could be real, it could be perceived, it could be something that we imagine, but this is a place where they put all these components and we choose one that we're going to spend that time on that day. It helps them compartmentalize in a healthy way. And it teaches them that we don't have to deal with every single thing on our plate. We choose to be the ones to prioritize what is most important to us at that time. And it really helps them cope in a healthy way. Systemic relaxation, grounding, meditation. These are all things that you certainly can teach clients without any kind of certification. Of course, things like yoga, you need a certification, but certainly you can refer them to yoga, discuss the benefits of yoga. You can teach breathing exercises. You can teach mindfulness in imaginative play, anything to help them relax, be able to think more clearly, and become engaged in the present moment of conversation. Appreciate the struggle of these clients. Validate the struggle of these clients. Make sure that you tell them this is their experience, this is their individual journey. Oftentimes, trauma survivors will compare themselves to other people. Appreciate the individual struggle and find that strength that you can offer to them from a strengths perspective standpoint. When we're talking about using information and psychoeducation, we really want to talk about the biology and trauma response. This is one of the biggest indicators of success and moving forward in treatment with someone who's had a trauma experience. So first, you can frame re-experiencing the event. You can talk about how that could disturb sleep, how that can make them hyper-aroused. You talk about the physiological reactions to extreme stress. You don't have to be well versed in this. You don't have to be a doctor. You just have to be you have to know about the physical responses to stress. It could be heart palpitations. It could be something that you're referring them to see their doctor. High blood pressure, headaches, changes in women's cycles. All of these are physical reactions to stress. Communicate that treatment and other wellness activities can improve their overall well-being and their trauma response. Therapy, meditation, exercise, yoga, going for a walk. These can help alleviate those symptoms and be able to help this client think more clearly. Discuss traumatic stress symptoms and their physiological components. It doesn't have to be specific to this client's experience. You're just talking wide, you're talking broad, you're talking that these are research-driven components. When someone has experienced a high level of stress, trauma, complex trauma, these are symptoms that they experience most often. We are trying to normalize this for the client. We want to explain the links between traumatic stress and substance use, if it's appropriate. Oftentimes, you may be seeing a client for substance use disorders, but they haven't disclosed a traumatic event. That's okay. We can do psychoeducation around substance use disorder, and we can just wait and ask questions as appropriate about any kind of history. But we want to do it slow, we want to do it methodical, and we want to understand that there is a high likelihood that this individual has experienced some kind of trauma incident. Again, you've heard me say this probably 12 times already. Normalize those trauma symptoms. For example, explain to the clients that their symptoms are normal. They're not a weakness. You'll hear clients say, I'm crazy, I'm damaged, I'm damaged goods, is something that a client said to me not too long ago. They talk about being flawed and that people don't accept them. Really kind of bring them back in and explain the research, the things that have been done to see the characteristics of a trauma response, to normalize that trauma symptom. So how do we begin? So obviously, when we are working in a crisis situation, we're going to start at the very beginning. This is the moment that this person is actively in this incident, this particular situation that is causing trauma. The crisis, when someone is dealing with crisis, what we know is that we are not there in a time of crisis to figure out the problem, to figure out what has happened to escalate the problem. What we're there to do is to get them down to about the closest that we can get to normal and functioning for them. This is not time sensitive. This is a particular point in time where we're actively engaged in a client who is experiencing a crisis. We want to make them safe, and we want to refer them to resources. Then when we get to that resource, let's say that you're a clinician, you are going to begin therapy by building rapport, going back to those components of trauma-informed care, establishing trustworthiness, all of those foundations that we need to build a healthy therapeutic relationship. If we begin therapy by focus on the trauma story, the risk is high that they will be re-traumatized, and it will add injury to the pain that they're already feeling. The early work should be focused on restoring their sense of safety, their connection, their sense of belonging. Their identity even is often one of the marks of restoring that safety. Helping the survivor to discover their strengths, drawing on their own resources, establishing or reconnecting with their support system, and self-regulation. None of these are trauma specific. None of these skills do you have to work on only after you hear their story. These are skills that you can instill while we are patiently waiting for an appropriate time for them to share their story. Only after a client has been able to achieve a reduction in alertness. And we're not asking their symptoms to be completely gone, them to be symptomatic free for an X period of time. We're going to monitor and see a reduction in alertness in their trauma response. We want to see a strengthened awareness of coping skills, their access to resources, using their resources. Then and only then should we consider directly dealing with the trauma story and asking for more information. You're the monitor of that. And it's also something that we need to be very transparent with. We need to engage our clients in that conversation. They are going to self-report their feelings of symptoms and alertness. You're going to ask them questions about their readiness to move forward. This is not something we decide on our own. This is something we decide mutually with our clients. This preparation reduces the odds that reviewing the trauma will cause emotional flooding and re-traumatization. And by asking them and preparing them, that can give them a sense if they're ready or not. Trauma is complex in its impacts and their symptoms and the way that we respond. Therefore, treatment has to be complex. We have to be ready with multiple skills, multiple communications, and multiple responses. We need to strengthen various aspects of their overall well-being, their social skills, their spiritualness, their cognitive ability, their physical symptoms, their emotional readiness, and overall self-regulation. So rule number one, as we're slowly moving through, rule number one is do no harm. We said that in the beginning when we were looking at the components of trauma-informed care. Affirm what the client is experiencing and how they are trying to make sense of it. So what are we doing here? We're really asking them about the story and we're making pauses. Throughout the story, we want to ask them, how does that make you feel? What has happened in this particular situation? How do you make sense of that? You want to monitor how it is that they're perceiving this particular trauma incident. You want to affirm them as an individual and the strength, the courage that they've had in dealing with all these forces in their life and how they are able to go on from here. Many of those trauma survivors that you'll be working with may say, I just can't do it. I'm not ready. I can't go on. They may not be suicidal, but they may just be giving up. This is where you're going to affirm that strength that they've had to this point and their strength to move forward. Offer your client a safe place where they can heal themselves in that safe place. And one of the best analogies that has ever come up is here below, like putting a cast on a broken leg. The cast is to protect the leg from further damage. The cast does not do the healing. The leg gets protection so it can use its own processes to heal itself. And that's what I think about our jobs being. We are that cast. We're protecting, we're providing some guidance, but it really is that client that will heal itself with our help, with our support, with our guidance, as long as we're using trauma-informed skills to do so. So when we talk about how we create this environment, it is incredibly simple to read, but unfortunately, so many agencies don't put these things into practice. So number one, environment of care. So often we walk into a nonprofit or a government run facility, and what we notice first is the appearance, the smell, the sight. Now think about some of the agencies that you may have been in, and how did you feel? Did you feel welcome? Did you feel warm? Did you feel supported? Did you feel safe? Did you feel secure? And when I started asking myself that, a lot of times my answer would be no. There was a distinct, stale neutrality that existed in how it was decorated. There was often a smell that wasn't pleasant, or too much of a smell that was overwhelming. Lots of times we walk to spaces that are not clean, they're not well maintained. Even approaching a building, overgrown bushes, not cared for in the front area, that speaks volumes to someone who desperately wants to have a safe place. We want soothing colors. We want nice, simple decor and paint. And I know that these things aren't always easy. It seems like we have to jump through hoops to paint our offices or for our lobby to be painted, but these are things that the organization needs to push for to do those very simple tasks that provide trauma-informed care for our clients. Overall quiet, sound machines, soft music. These provide two things. Number one is that ambient music, but it also protects confidentiality. Carefully placed psychoeducation information. Oftentimes brochures that are out in the middle of a table where everyone can see who's taken what are not ever taken with the client. We want to make sure that they're available yet discreet, so someone can take information without being judged by those other patrons and clients in that facility of what it is they're taking. Neutral or pleasant aroma. Again, Oftentimes there is a overwhelming smell where someone is using diffusers or candles or some kind of just distinct smell. Others, it's stale, it's musty. We often use older buildings. Be very aware of these kinds of things. Individual chairs with discrete seating options, someone who may want to come in and isolate themselves from the others in the lobby, may not sit right next to someone. A clear and welcoming entry sign, a clear and welcoming space when they come in, a very easy way to find who it is they check in with if we're looking at a clinic space. Individual bathroom options. I never really thought about this until I had a client who was sitting in the lobby of an agency who got very overwhelmed, had an anxiety attack, and went to seek a bathroom. But the bathroom that was an option for her was 3 stalls. There was doors on the stalls, but she was very upset about who may hear her. She was sobbing. She didn't want to be asked if she was okay. She was using her skills to get through this anxiety attack. What she really wanted to feel very safe was an individual bathroom. And that's something to consider. I know we can't always change our space that drastically, but it's something to consider and talk with our clients about. Staff appearance. This should be, more common sense than it appears that it is. Good general hygiene. This is something that we want to present, that we want to be professional. We want to have attire that looks professional. It's easy to identify staff members versus just someone coming and going, whether it's a lanyard with a name tag or a polo shirt with the name of the agency, something to easily identify a staff member. Particularly for that client I told you about that was looking for a restroom. She was wanting to tell someone that she was there, that was a staff member, to come get her therapist, but she wasn't sure who in the hallway coming and going actually worked there. There was no lanyard, no identification, no nothing. So she was actively seeking a staff member to get her therapist, but couldn't really figure out who was a staff member. Clothing that fits appropriately, not overly revealing. And yes, we don't want to take away your autonomy and independence in choosing what it is that you wear, but do realize that those who have had some kind of trauma related to sexual inappropriateness, sexual assault, etc., the revealing clothes may be a trigger for them. I had a client whose clothes were ripped off of her. She was very aggressively assaulted. And so to her, if she would always wear clothes that were higher on the neck, she didn't want to see that area at all. So it is highly likely that she could be triggered by someone who had a plunging neckline. So these are things that we have to think about. Religious icons, political icons, discreet jewelry choices. Think about how you arrange your room and your office and what kind of things that you display there. Again, the idea is not to take away your opinion and your autonomy in having these things displayed, but just be very cautious about what it is and what it could mean to someone. I have a colleague who has lots of pictures in her office, as we all do, her children, her animals, things of that nature. And she was seeing a client for marital issues. And she noticed that her client would not stop looking at her desk area. And so she didn't look at it while she was with the client, but she kind of analyzed her desk area after her client left, and thought the only thing there was her computer and some pictures of her family. And so she decided the next time to remove those pictures and anything other than her computer on her desk. When the lady came back in for the next appointment, she was a little bit upset. She was a little put off. And so my friend asked her, "Why is it that you seem a little overwhelmed today?" And she said, "I was really looking forward to seeing those pictures there. I was really looking forward to seeing those pictures there. I really enjoyed looking at those pictures. It gave me a lot of hope." So in that conversation, asking very minimal questions, it led to this particular lady disclosing that she had had some miscarriages. She had longed for a family, and her husband did not want to discuss any kind of alternatives to pregnancy. So that really was a trigger for her. Seeing that family and see that idealization that she really wanted became a trigger for her. Staff behavior. Far too often, I think we forget, when we're not in our offices, when we're in our lobby, our hallway, maybe in the elevator, even in the parking lot, we're still in eye shot of our clients. They see how we're handling ourselves. They see how we're interacting with each other. And we want to be very aware of these kinds of things. We want to demonstrate proper manners and respect for one another. We want to respond to requests for help, even if it's not our client. If we have someone in the hallway who's asking directions or seems to be having a really challenging time, we want to check in with them. We want to do it quietly. We want to do it as discreetly as possible, but we're not doing them any favors by just continuing to mind our business and going on to wherever it is we were going. We want to speak in clear, normal tones. Oftentimes we find ourselves speaking differently, using different language, different adjectives, speaking softer or louder when we're dealing with someone with trauma. We want to make eye contact when it's appropriate. This is where our cultural competence comes in. We have to know the clients that we're working with. And if you don't know, ask. Oftentimes we see ourselves as a social worker extraordinaire and that we should know everything about every culture, and we don't. And we just need to ask those questions. Would you like me to give you a handshake? Is it okay if I make eye contact with you? Can you tell me a little bit about what is culturally preferred for you? That's a simple question that gets a lot of that out of the way. I know that we have rough days, we have hard clients, we work in agencies where we might feel unappreciative, but still smiling and demonstrating a pleasant demeanor means the world to clients, especially when they're struggling with trauma. Be very mindful of confidentiality in open common spaces such as the lobby. Oftentimes those who are administrative secretaries, billing, HR, they are there up front and they're managing clients coming in. And oftentimes those conversations are said very loud. There's information that is given that should not be given. And those things can really cause a negative trauma response. Open physical stance, make sure that we're keeping in mind our nonverbal gestures and our body language, keeping our nodding and make sure that our nonverbal skills are there. Initiate greetings, offer water, don't eat in front of clients. I know oftentimes we have back-to-back days and we had an emergency and we're just getting down to eat something, but it's not appropriate to do that with our clients. And I know that many of you are probably thinking, these are so simple and these are things that I clearly don't do, but so many do. And that's why we're talking about them today. Be open to change, be open to constructive feedback in how it is that you are working with clients. That cultural competence again, and nonverbal gestures and staff conversations. I've had so many clients over here, conversations between staff. And they feel as though that might be happening about them, where staff is talking about someone in the lobby or a client that they just saw. And my clients are wondering, wow, are they doing that about me? So we want to make sure that that's not happening. From an organizational perspective, we have to make sure that trauma-informed care is important, that there is a trauma policy and philosophy in place organizationally, that there is a procedure and a policy that is available for the employees, that there is training that is available. There has to be a commitment that is articulated to be trauma informed from the top down. All staff, clients, family members, supports are taught about trauma and its impact. It's hard to be trauma informed if you're not given the appropriate tools to be effective and be able to teach this. Incorporate a universal trauma screening for all clients, period. It doesn't matter if they say or don't say that there has been a trauma experience. It doesn't mean that you have to know or you don't know that there's been a trauma experience. This is universally given to every client that comes into your agency. Trauma status continually assessed. Many times clients, when given a trauma screening, they know what's being asked and they're not ready to disclose. So their answer may be no, no, no. So periodically, we're going to check in about trauma. We're going to ask questions about trauma, because after we've offered this safe and healthy and secure environment, there might be a disclosure, but we have to assess for that and we have to give them the space to talk about it. There has to be a clear organizational plan for dealing with behavioral crisis. I cannot say how many agencies that I've consulted with that there is no safety plan for staff. There is no staff or administrative policy on dealing with a behavioral crisis, period. That has to be in place. There has to be discrete areas in your organization for calming clients or for crisis management. These are areas that are truly trauma informed, from the environment to the staff dealing with this issue. Feedback valued. So oftentimes we give our clients surveys and we ask about how we're doing. Well, it doesn't matter if we give the survey and we ask if we don't incorporate that into some of our policies and how we do business. We have to have concerted efforts to reach these clients where they want to be met. And I have just some helpful links throughout here when you guys are able to access the PowerPoint. I think would be a very valuable resource for you. Treatment considerations reflect the client's preferences. That could be from their cultural traditions and beliefs to where they want to work first. They're integrated across the disciplines. We have to have a multidisciplinary approach when we're working with a survivor of trauma. Consent for treatment is explained far too often, even in our non-trauma informed care environments. We are not explaining the treatment consent exchange forms. This has to be fully explained to be able to work in a multidisciplinary way. Offer choice of treatment provider when possible. Sometimes it is just who you represent that causes a barrier between the client and being able to work on trauma. It could be me as a white female is triggering to my client. I don't need them to tell me that, but I need to ask a question. Are you okay with me as your provider? We have other alternatives if someone else would be a better fit for you. I'm not asking them to tell me what's wrong. I'm not asking them to explain to me why I'm not a good fit. I'm giving them choice in being able to choose a provider they feel most comfortable with. We have to realize that it's not about us, it's about perhaps what I represent for them in their trauma story. Using everyday language, staying away from acronyms, therapeutic language without explanation, etc. Respond to all statements of abuse. This is oftentimes a way that someone is trying to make a disclosure that happened maybe previously, and they're making this statement of abuse about the present day. It could not be factual at all, or it very well could be factual and it's ongoing abuse, and we have to take all statements very seriously. We have to be sensitive to the seating configuration of our office, the proximity of us sitting with them. If you're conducting family therapy, make sure you have options for seating. You want to be able to allow the client and the family members to sit where they're most comfortable and with the distance that they would like. Co-occurring treatment needs assessed. You need to look at co-occurring disorders along with trauma and make sure you specialize or can refer to a specialization in that area. Again, culture of origin respected and incorporated into the planning. Recognize the importance of physical boundaries. Offer to them a handshake. If they say no, that's fine, move on. Offer a high five, offer no touch at all. Just make sure that they are a part of that decision making. We have to realize that oftentimes trauma survivors feel so much out of control that even a very small choice can be a big deal to the trauma survivor. Recognize the importance of social boundaries, joke telling, storytelling, innuendo. These can convey risk or threat, or it can be taken in a way that obviously you didn't intend, or it could be overheard and there's no communication with you all. And now that joke or that innuendo has been taken as that person perceives it, and that could be really dangerous. So one of the things that I want you to walk away from this training today, if the only thing, is this slide right here. This is probably the most important question in how you frame it. This trauma-informed is a shift in how we ask questions. We're going from what's wrong with you to asking what has happened to you. And you can see just in that slight change of language, we're really taking any ownership off of that client. What has happened to you? It means something has been put upon you. What's wrong with you can sometimes convey ownership or blame. And so just that simple way of asking a question is a huge way to start your trust and your rapport with your client. And you can see here the trauma-informed wheel, as I call it. All of these things, again, are part of the components that we talked about early on. And I have shared this with my clients before, and I've talked about what each one of those circles means and what I'm going to do as their clinician in meeting each one of those. And I asked them to engage with me and tell me what it is that they could do in each one of these circles where we can have a really healthy relationship in moving forward. This sets a precedent that we are working on trauma, maybe without talking about the specific trauma at that time, and that I am going to provide these particular things to them, and mutually they're going to provide these things to themselves. Building resiliency. There's a toolkit that is awesome. It's based off of ACEs. There's a link there for you. But I want to talk just for a second about secondary traumatic stress. So when we're working in this environment where we're dealing with trauma and crisis so often, it behooves us to make sure that the number one priority is us. This is where we get to be a little bit selfish. It takes me back to something that a lot of our grandmas used to say: if you don't love yourself, then no one else is going to love you, right? Well, the same goes for here. If we don't care for ourselves first, we're not going to be able to care for those that are coming in with trauma and other related issues. We have to be intentional about vicarious trauma. We have to have an organizational stand that makes support available for all the employees. There has to be a recognition of the impact on secondary trauma. This is huge. And more often than not, recently, I've been asked to speak about secondary trauma and what that looks like as a social worker or helping professional. This is huge right now, especially coming out of a 14-month pandemic. Recognizing exposure to trauma is a risk of the job serving traumatized children and families, and it should be acknowledged. There's nothing worse than being told it's just part of your job. You signed up for this. No, you signed up to be supported and to be maintained as a valuable worker within this job. Understand that trauma can shape the culture of organizations in the same way that trauma shapes the individuals that we're working with. Think about morale. Think about the lack of support versus a lot of support. It changes the culture and the environment in which we work. Develop the capacity to translate trauma-related organizations and knowledge into meaningful, action-oriented policy, and improve that practice within the organization as a whole. Not just a few units, not just a few departments, not just a few people, but as a whole, so that it is known that there is that support and there's a capacity to realize the symptoms and the exposure of trauma. be integrated into direct services, programs, policies, all of it. Like I just said, the whole shebang. It has to be training facilitation. There has to be staff development. There has to be activities directed at secondary traumatic stress. If we don't talk about it and we don't acknowledge it, then as an employee, you often feel like it doesn't exist and it's taboo for you to bring it up. Okay. This is a really, really good organizational chart about trauma-informed care. Again, it has to start at the top. The senior leaders must prioritize trauma-informed care. They demonstrate it through offering training, through their behavior. They model that for their employees. They give priority to trauma-informed care. Then it goes to support staff. They're given training, coaching, supervision, debriefing, everything around trauma and crisis. And they discuss work-life balance, self-care, things that really start to incorporate that coping ability. That translates into listening more effectively and actively to the clients and families. Clients and families are consulted and included in their own self-care plans. And you see how this works. There's a nice flow. The leaders are able to recognize it. They're passing that off to staff. Staff is healthy in a good place, feeling very supported. They pass that on to the families. And then that is passed on to a data or non-judgmental regulated share with staff and used to motivate continued improvement. So this is a cycle. It continues. And then we continue to align our policy and practice of trauma-informed care organization-wide. In the organization, a few things that we do want to incorporate as we're looking at policy is adequate clinical supervision, making sure there's time to debrief, to process, reflect. This is where we really are able to talk about and process our trauma, our cases, our clients, our workload. We want to maintain a trauma caseload balance, making sure that just because somebody's really good with this population, they're not carrying all of the trauma survivor caseload. We want to support workplace peer-related self-care groups. We want to enhance the physical safety of our staff, offering flexible scheduling, caseload caps. We want secondary traumatic stress training for our clinical staff, our administrative staff, all of our staff, our clinical staff, our non-clinical staff. Everyone needs to understand. Train our organizational leaders, let me back up, on organizational implementation and assessment. How am I able to incorporate trauma-informed care into my organization? It sounds like a really great idea, but how do I do it? We need to make sure there's an assessment there. And providing an ongoing assessment of staff risk and resiliency. For yourself, without your organization being involved, use supervision, consult with a colleague, make sure that you're processing with someone appropriate. Increase your self-awareness. Oftentimes, we don't want to be aware of what secondary traumatic stress looks like for fear that we are feeling it. Maintain your healthy work-life balance. And I know that those are so easy words to say, but it's harder to do. And I think what I'm asking here is that you guys just become aware of it. Exercise, good nutrition, sleeping, staying connected, particularly staying connected with your friends and family who are not in the helping profession. That does wonders for my self-care. Develop and implement plans of personal wellness, resiliency. Take a risk and resiliency inventory for yourself. We're so good at giving them to our clients. Take one yourself. Do a self-awareness wheel. Start looking at how you're doing and not just asking clients how they're doing. Look at risk reduction, how self-care routines are working or not working. Use your EAP. And if you can, participate in a buddy system, someone that you work with, someone that is a colleague, to make sure that you're holding each other accountable. So screening tools, we don't have the time to get into these today, but I did want to provide you guys with some resources. These are some of my favorites, some that are widely used, particularly in outpatient types of settings. And then treatment for trauma, just a few trauma-focused CBT is evidence-based. I know a lot of you work in agencies where you have to have an evidence-based practice. It's components-based treatment model that incorporates trauma-sensitive intervention with CBT. It brings in family. It's proven successful with children and adolescents. This is one of the hardest populations to reach when we're talking about trauma and all of the hormonal changes, developmental phases that this age group is going through. This has been proven to be very, very successful. This works for complex trauma, a single event trauma, or multiple traumas in their life. EMDR, this is something that I know many of you are probably familiar with. However, the caveat here is no one just needs to go to EMDR. What needs to happen, and there needs to be some monitoring, there needs to be some disclosure, there needs to be readiness to talk about and process the trauma event. So this is something that's highly successful, but we don't just assess for trauma, find out there's been trauma, and throw our client into EMDR. This is very much for someone who is working with a therapist, and we are making sure that they are actively ready for EMDR and to retell their story. So these are, again, some helpful resources. There are a lot of these out there. The links that I provided to you guys are all toolkits, evidence-based work here. There's some continuing education there in the first link, but I just wanted to provide some more information for you guys, for you to go into a little bit more depth with trauma. And that is going to conclude my piece for today. I hope that I was on time. I tend to like to talk a little bit too much, so I think I'm on time, and I appreciate all of you being here and for your attention.
Thank you, Ms. Garino, for your presentation. I think we have a few questions in the chat, and
Sure.
And so I ask them now. So what are some tips on how to apply these? What are some tips on how to apply these tips when the person is already in crisis mode? They may not be able to listen, reason as effectively. And I think that question came up earlier in your presentation. So
yes. So when someone's in active crisis, we obviously are not going to ask them to tell the story. You then are just dealing with that crisis. When you think about a crisis or someone being in crisis, it is present moment only. We're not going to talk about their relationship with their mom when they were 5. We're not going to talk about 2 weeks ago or 2 weeks in the future. We are present in that moment, and we're with that client as they're going through this crisis. So we're only focused on just that crisis and the symptoms of that crisis, if that makes sense. So if someone is experiencing, I'm trying to think about a good story to use. If someone is experiencing self-harm, they're not suicidal, and we know that that has a direct correlation to previous trauma, and this is the crisis at hand, is that they're self-harming, they've never self-harmed before, we're not going to ask that client to engage in discussion about trauma. We're going to give psychoeducation. We're going to assess the self-harm that's happening in that moment and resource whatever's the most appropriate action for that self-harm, keeping them de-escalated or de-escalate them from where they are and just monitor that moment. I hope that helps.
okay. All right. The next question we have is, many older people have long-standing unaddressed trauma and are now experiencing cognitive disorders. Do you have some techniques that might be used in these situations? Often behaviors, quote unquote, are mistaken for coping.
Right. And you know, the very unique piece of that question is oftentimes behaviors are coping skills that have been learned throughout their interaction with others from the time they experience the trauma. There's many aging adults that experienced trauma 40, 50 years ago. The unfortunate part about that with the aging process and distortion in their memories, the the story is not going to be the story that it really was. I know that was a very strange way to get to that point. So oftentimes you, again, very much like someone in crisis, have to stay with them in that moment. So if they're displaying behaviors, we don't think about asking a aging adult, why are you doing that? That seems like such a childish or adolescent question. Why are you behaving this way? But oftentimes that is the best conduit of information. It's just simply asking, why are you having these behaviors? Why are you slapping the pills out of your nurse's hand? And although you might not get a great story of what happened to them 30 years ago, it gives you that trust between they just want to tell a story. It may not be the accurate story, but they just want to tell a story. And I've had aging adults say, I'm just mad. And so we talk about feeling angry. And a lot of times it has a direct correlation to the trauma, but it's more in the terms of, I don't feel independent. I don't feel autonomous. I don't feel like I have the ability to make decisions. And, the nurse just coming in and telling me to take these pills, I just slapped them out of her hand because it felt good. So that's where you stay with the aging adult. There are some that have a really good recollection, although we would never know if it's true or not, about a trauma event. And again, whether it is real or perceived, factual or not, sometimes just offering them that space to tell you the story is symptom relief enough for that aging adult. They likely don't have the support system that they did. Maybe family members are deceased. Some of them are seeing their supports and their friends be buried. And so it's very lonely. And oftentimes they just want to tell a story. And it's not our job to be the fact checker on it, but just allow them to tell the story. And you might see some behaviors decrease, some negative behaviors decrease once they're able to process and vent that story with you.
Thank you. I don't see any other questions in the chat, but does anyone else have any questions? I think we have about 3 minutes left. So just a few minutes, but if anyone has any other questions, please feel free to type them in the chat. If you feel comfortable taking your mic off or turning your mic on, or turning your camera on, then you can do that as well.
Hey, Tadra, this is Kevin. Actually, I saw a message in the chat, and I was going to just let Michelle know this, and maybe she may want to respond on it. It says a friend in another state who counsels people in crisis is required by her county to have a relationship with a personal therapist and see that therapist at least once a year. And I just thought I would ask you your response on that. To me, it sounds great, but I just thought
Yeah. It does sound great because, I'm going to give you kind of my personal opinion. Where we really see change when we're working with someone who's had a trauma experience, we're about the 12-month mark. That's really where you start to see commitment to change. That could obviously change from person to person. That also sounds like there could be a situation where this person has found themselves in criminal court. And because that is not the good place for someone who's experienced trauma, there might be a bench order or a court order for them to participate in some kind of treatment programming for up to a year or more in lieu of being charged. And we see that a lot in North Carolina. I work with our court system, those who have mental health concerns, those who've experienced trauma and have had some symptoms that result in poor decision-making or criminality will often advocate with the judge presiding and say, can they enter into therapy in lieu of criminal charges? And that is very successful. And there is a time stamp on that. North Carolina does not have any kind of just arbitrary, without them being criminally involved, kind of stamps of time for someone to participate in therapy. However, I think that's an excellent point. I know that some of my programs that I've built for gang involved kids, because the time for change is really about 12 months. I ask them to participate for 12 months. And if they don't participate for the full 12 months and they decide that they want to to get out of the program, they have to start over at 12 months, because really, or at month 1 for 12 months, because really when you start to see that change is at that 12-month mark. So I'm not real sure what state and what kind of criteria.
Michelle?
Yes.
Michelle, that was not what I was saying. I have a
Oh,
friend
okay.
who's got a master's degree in counseling, and she counsels in the school system. And as part of her job requirement, they require that she maintain a relationship with a therapist and see that therapist once a year. And I know North Carolina is probably not moving to
Got
that,
it.
but I think since there is money now, that needs to be
Yeah.
examined, because you can't really treat people if you're hurting.
Exactly. Yes, that makes more sense now, but it was very interesting either way. But I do think that we need some kind of, I don't know if it would be a policy or what. I think we really need to look at the availability of therapy for those who are giving therapy. Right now, it's just, I'll go see one if I need one. There needs to be that commitment to have a place to process. And really, honestly, after you get your license, I mean, you have that, post 2 years of work where you're getting that weekly supervision. After that, when you're fully licensed, when you probably need it the most, there is nothing that's holding us accountable to that therapy. And Lisa, I love that. And I think we need to incorporate that. So anybody that's doing lobbying and that kind of work, I see peer support. Yes, peer support is a great thing. Unfortunately, peer support teams are more widely available for law enforcement and first responders. One of the driving forces behind peer support teams is the fire departments in North Carolina. They have a wonderful, wonderful program of peer support. And then we have what's called CISM teams, it's crisis intervention teams that are deployed when there's been a pretty major incident to go out to first responders and us as helping professionals and debrief us as people who were not directly tied to that event. So there are resources, but we don't, I wish we had more, I guess is the best way to end that note.
Yes. Yes. I see there are comments in the chat about we lose great social workers in CPS and APS because of untreated secondary trauma and burnout. Absolutely.
All the time.
I can imagine. So I think we're at 3:17 now, but if anyone has maybe a question for Ms. Garino, please feel free to type it in the chat. She may have time to answer maybe one more, even though we're already over time. But it seems like this presentation has been very helpful to a lot of people. So we want to make sure that if you have any questions that you have time to answer or get answers for your questions. All right, I don't think we have any more at this time. Thank you, Ms. Garino, for presenting to us this afternoon. It was a great presentation, very timely given the pandemic and all the things that have happened this past year. So thank you so much for being willing to join us today.
You're welcome.
Thank you, Tadra and Michelle, for both your presentation. It was a wonderful job. And we saw lots of great comments in the chat saying, wonderful presentation. I think we're going to have you back next year. Hopefully we'll be in person so that we can have you. I think you could talk on secondary trauma probably for a whole nother hour as well. So I think we, for the conference committee, I think we already have a topic for next year already.
Well, thank you. I'd be happy to. I love face-to-face so much better than virtual, but kudos to you guys for continuing to hold this, and thank you guys for everyone who attended.
Thank you. And as we do wrap up today, we do have several things we want to talk about before we end for the day, and to give you some reminders as we do go into our final day for tomorrow.